All right, folks, Chapter 11 looks at capacity and incapacity. So, Greek philosophers recommended that people with a mental disability be cared for in a comfortable, sanitary, well lit place. And Romans appointed a quote unquote curator to safeguard the property of these people and debated the legal effects of decisions made by the ward, the person being cared for, during lucid moments. In the Middle Ages, definitions of mental disorder were influenced by theories of possessions by demons and exorcism, and torture became primary therapies. England then divided those with mental disabilities into two classes: idiots, those that hath no understanding from his nativity, and lunatics, persons who have had understanding but hath lost the use of his reason. So competency appears in many types of laws: evidence, contract, wills and estates, domestic and family law. So looking at competency in the civil justice system, one type of competency we're looking at here is the ability to make a contract. So contracts are only valid and enforceable when the parties are capable of understanding their mutual obligations. So generally we consider minors to have diminished capacity in this regard. And so this is why most people under the age of 18 cannot enter into a contract. Now, when they do enter into a contract, that contract is considered voidable. Also, those so disabled by mental illness that they're unable to understand the nature of a transaction in a reasonable manner also usually lack the legal capacity to enter into a contract. But this is usually evaluated on a case-by-case basis. Now, temporary incapacitation, like intoxication, can also usually void a contract. And one determining factor here is whether the other party was aware of the incapacity but proceeded with the agreement, so therefore they're taking advantage of another's known incapacity. Testamentary capacity refers to the competency to make a will. And these are contested usually on one of two factors. One, that the person making the will lacked testamentary capacity, so perhaps they were mentally incompetent at the time they signed the will, or that the person making the will was subject to undue influence. Determining this requires careful review of medical, psychiatric, nursing home, pharmacy, and other relevant records to reconstruct the mental state of the testator, the person making the will, at the time they were made the will. So a forensic examiner should address these issues and whether the testator had the capacity to understand, know, or recognize that 1, a will is being made, 2, the extent of his or her property, and 3, any potential heirs. Now, a testator with a drug or alcohol issue doesn't lack testamentary capacity if the will is made during a period of lucidity. But chronic drug or alcohol use could result in medical and psychiatric conditions that can impact their mental state and make them susceptible to undue influence. Now, informed consent is the process by which a fully informed patient can participate in choices about his or her health care. This should address reasonable alternatives to the proposed intervention, risks and benefits of that intervention, and an understanding of the intervention. Now, informed consent in terms of research, generally psychiatric patients are not more likely to volunteer to participate in research. And in fact, depressed people are 6 times more likely to decline any pharmacological trials, and 96% of schizophrenic patients decline research opportunities. But we do want to make sure that anyone participating in research, where they're the subject, that they do have informed consent. Now, there's 2 ways to protect people who are incompetent to make decisions for themselves. One is through guardianship, which is a legal relationship between a competent adult and a person who's no longer able to make responsible decisions. And a conservatorship, where there is a court-appointed relationship in which the conservator becomes the surrogate decision maker for matters concerning property and income of the person deemed incapable of administering his or her own financial affairs. Now, what about competency in the criminal justice system? This is the capacity to comprehend the legal proceedings and work with your attorney to understand and waive certain rights. Now, in 1899, a federal court of appeals said it is not due process of law to subject an insane person to trial upon an indictment involving life or liberty. So in Drope v. Missouri in 1975, the court held that the right of an incompetent defendant to avoid a trial is fundamental to an adversarial system of justice. Now, the authority to control citizens and even incarcerate them comes from three places. One is our police powers. Police powers authorize states to protect the community and to incarcerate individuals who are threats to the public or had committed crimes. Another place this comes from is parens patriae. This is the idea of the state as father, and it's mostly used in our juvenile justice system, that basically the state is the general guardian of anyone who cannot care for themselves. And then the third place this comes from is civil commitment laws. So competence to stand trial refers to your ability as a defendant to function in a meaningful fashion in a legal proceeding. And this is relevant at every stage of the criminal justice system, but generally gets raised prior to trial occurring. Now, why do we require that someone is competent to stand trial? We want to make sure that legal proceedings are accurate and just. Also, because punishment is really only acceptable if the defendants understand why they're being punished. And finally, the fairness of our system requires participation by defendants who have the capacity to defend themselves. And so this is based on our Fifth and Sixth Amendments. So with a guilty plea, a defendant is waiving their right to be clearly informed of the nature and cause of the charges against them, to prepare an adequate defense with the assistance of counsel, have a jury trial, confront accusers, and call defense witnesses in their defense. Now, in Dusky v. U.S. in the 1960s, the Supreme Court set forth a definition of competency to stand trial. So first, the competency test rests on two prongs: the capacity to understand the criminal process and the ability to function in that process. It focuses on your present ability to assist counsel. Capacity to relate to counsel and understand courtroom proceedings is paramount. The person must possess a reasonable degree of understanding of the criminal process, and it emphasizes the presence or absence of a rational and factual understanding. So this suggests an emphasis on cognitive functioning. Now, in 1993, the courts held that a decision to plead guilty is no more complicated than the sum of the total decisions that a defendant makes during the course of a trial. So we don't need to set a higher standard of competency if someone wants to represent themselves in court. Basically, if they want to act as their own attorney. So let's look at some constitutional issues and standards of care. So the right to liberty is at the center of all rights relating to anyone that's in state confinement. And this is basically the legal rationale for lawsuits of false imprisonments, negligence, or intentional infliction of harm. Now, in Anaya v. Crossroads Managed Care in 1999, a group of individuals had been detained on an emergency basis to a detox center, but they hadn't been committed due to dangerousness, as the law requires. So it's not just a requirement that somebody has a mental disease or defect, but they also have to be dangerous in order to be committed against their will. Now, there's also the right to safety. So an involuntarily committed resident of a state mental retardation institution have a constitutional right to reasonably safe conditions of confinement and freedom from unreasonable bodily restraint and habilitation. In Youngberg in 1982, a young man was injured repeatedly and placed in restraints for long periods of time. Now, his mother filed a civil suit stating that officials knew or should have known that her son was suffering injuries and that they failed to take appropriate preventative measures, a violation of both his 8th and 14th Amendment rights. Now, on appeal of the case, the APA, the American Psychological Association, submitted an amicus brief and said that mentally retarded people can learn and respond positively to instructional programs. So where the state has custody of a non-criminal mentally retarded person, it has a constitutional obligation to protect him from harm by meeting his fundamental needs. And the Supreme Court agreed with the APA. Now, prior to 1975, there was never any clearly defined right to treatment. In an O'Connor v. Donaldson in 1975, the Supreme Court said an involuntarily civilly committed person does have a constitutional right to receive such individual treatment as will give him a reasonable opportunity to be cured or improve his mental condition. And in Watt v. Stickney in 1970, a case that was finally dismissed in 2003, they created minimum standards of care. These include humane psychological and physical environment, qualified staff and numbers sufficient to administer adequate treatment, and individualized treatment plans. Patients also have a right to a least restrictive alternative. Basically, we need to hold you in the least restrictive facility that will allow us to address your needs. So this led to people moving from larger to smaller facilities, group to individual residences, dependent to independent living. And in the Olmsted case in 1999, it's looked at the unjustified institutionalizations of persons with mental disabilities and found that it violated Title II of the ADA. So patients have a right to integrated services under less restrictive conditions, including limited rights to community-based treatment. Now, what about the right to refuse medication? Until the 70s, you could forcibly medicate people. The idea here was since they were involuntarily committed, they were deemed incompetent to veto treatment decisions. But today, you can refuse psychotropic medication. Now, in 1990 in Washington v. Harper, this case looked at an inmate in a prison. And the APA argued that due process requires a prisoner receive an impartial hearing before being forced to take psych meds. Forced medication implicates basic liberty interests, and prisoners have a right to refuse invasive and dangerous therapies. Now, the court did hold that Harper did have a substantive liberty right here, but also that the state has a legitimate interest in reducing the danger that a mentally disordered, violent inmate poses. And so the due process clause does permit the state to treat a prisoner or inmate who has a serious mental illness with psychotropic meds against his will if he is dangerous to himself or others, and the treatment is in his medical best interest. So about 2% to 8% of all felony defendants are referred for a competency evaluation. And usually this focuses on the presence or absence of psychosis. But this alone is not sufficient for a finding of incompetence. There is no diagnosis that always renders someone incompetent. Now, one thing we also want to look for is the question of malingering. Malingering is basically where you're faking. And this is always relevant in competency cases. And in 1982, in a case in Maryland, the court held that because of the potential for fraud, amnesia doesn't justify a finding of incompetence. You would still be competent even if you have amnesia, if you have the ability to consult with your attorney and participate in the legal process. So what about when you're doing an assessment for competency? Before meeting with the defendant, you should speak with both the prosecution and the defense. You want to find out why this request has been made in the first place. You want to obtain all relevant aspects of their family, developmental, mental health, social, and criminal history. If there was any prior mental health treatment, you want to obtain those clinical and hospital records. You also want to make sure you get complete police reports of the incident in question. You should maintain a record of when and from whom information was made available, as well as all contact with members of the criminal justice and mental health systems. Ideally, you want to make an audio or audio-visual record of the evaluation, but first obtain written permission from your defendant and make sure you're aware of any statutory requirements. You want your evaluation to be of the highest quality. Reports should separate factual information from inferences. Now, a poorly written report can be used to discredit the author. Now, once that evaluation has been completed and the report is submitted, the court may schedule a hearing. But if the defense and prosecution agree, a hearing may not be needed. Now, if you're found not competent to stand trial, that trial will be postponed until your competency is regained. Now, prior to 1972, there's no direction on how long someone could be held. And in Jackson v. Indiana, defendants were committed solely on the basis of incompetency, cannot be held more than a reasonable period of time necessary to determine whether there is a substantial probability that he will attain that capacity in the foreseeable future. But the court didn't specify a time period. Now, competency for juveniles is also important. One study examined the competence to proceed. This meaning the ability to understand the purpose and nature of the trial process, the capacity to provide relevant information to counsel and to process that information, and the ability to apply information to one's own situation in a manner that's neither distorted nor irrational. Now, the youngest group, those that were under 15, were nearly 3 times more likely than those older than 15 to be significantly impaired in this ability. So if you're found incompetent, can we restore your competency against your will? Now, in the criminal justice system, you do have a reduced right to refuse unwanted medical treatment, even if you have yet to be convicted and you're simply awaiting trial. But the state often makes arguments for forced medication. They might need to halt the spread of disease within a prison, ensure the physical safety of prisoners and staff, and also to restore the competency so that someone can stand trial or be executed. Now, in Riggins v. Nevada in 1992, this case looked at medicating a mentally ill prisoner who had not yet been convicted. And the court said he could not be involuntarily medicated unless the state first showed that they had tried less intrusive means in order to restore his competency and that he was a danger to himself or others, which they did not do in this case. Now, in U.S. v. Weston in 2001, the federal court set a precedent for forcibly administering medication. Weston was a paranoid schizophrenic, and his symptoms rendered him incapable of understanding proceedings. So there were 2 administrative hearings and 2 district court hearings, and as a result of those, the government did obtain an order to medicate him. Now, criminal responsibility is different from competency. Criminal responsibility refers to the state of mind at the time of the crime. And this is a legal term, okay? So insanity is a legal term. It's not a medical term. It's the conditions which render an affected person unfit to enjoy liberty of action because of the unreliability of his behavior, which can include concomitant danger to himself or others. Basically, it's thought to interfere with free and rational decision-making, thereby making someone incapable of forming criminal intent or mens rea. Now, in the 13th century, as mentioned earlier, or in a prior chapter, the English Lord Bracton said that some people simply do not know what they are doing and act in a manner, quote, as to be not far removed from the brute. So here, insanity means someone who doesn't understand what they're doing. Now, in the 14th to 16th century, we're looking at the difference between good and evil. And in Rex v. Arnold, jurors were instructed to acquit the defendant if they found him to be totally deprived of his understanding and memory, and doth not know what he is doing, no more than a brute or a wild beast. So here it's less about morals and more about cognitive failings. In 1840, in Regina v. Oxford, the argument here was because of a diseased mind, the defendant was unaware of the nature, character, and consequences of the act he was committing. Now, the M'Naughton rule comes from England, and M'Naughton shot and killed the British Prime Minister's secretary in 1843 and did also try to assassinate the Prime Minister. And he was found not guilty by reason of insanity. Now, in America, the Naughton test required clear proof that the individual was, at the time of the offense, operating under defective reason from a disease of the mind, and that such a defect resulted in the individual not being able to recognize the nature and quality of his action or not knowing that the action was wrong. And this was the standard until the mid-20th century. Now, another standard is the irresistible impulse test, or the Durham test. And basically, critics of the M'Naughton test argued that cognition is only part of that we also need to capture this volitional aspect. And so under the Durham test, a defendant could be acquitted if his reasoning powers were so far dethroned by his diseased mental condition as to deprive him of willpower to resist the insane impulse to perpetrate the deed though knowing it to be wrong. And this is adopted federally in 1954, but never received wide acceptance in the U.S. Now, in 1962, the American Law Institute drafted a model penal code, and some states have used this either as a model for what they're going to write for their penal codes, or they've adopted it wholly. And in the model penal code, the way they addressed insanity was that a defendant is not responsible for criminal conduct where he or she, as a result of mental disease or defect, did not possess substantial capacity either to appreciate the wrongfulness of his conduct or conform his conduct to the requirements of the law. Now, this is very vague. It recognizes degrees of incapacity and really leaves this up to the jury. And about half of the states have adopted this model. Now, the reality of the insanity defense is that it's employed in only 1 out of every 200 criminal cases, and it's successful less than 1% of the time. It also does not lead to an immediate release. Generally, people are going to be confined to a mental hospital for an indeterminate period of time, and this could actually be even longer than what they would have served if they'd been found guilty. The criteria for release here is very restrictive, and a typical NGI is a seriously disturbed, marginalized member of society who's most often an unemployed white male in his late 20s or 30s with a history of prior hospitalizations and or arrests. So after John Hinckley's found not guilty by reason of insanity using the Durham test, Congress and half the states enact changes in their insanity defense. And 12 states create a guilty but mentally ill verdict. You're still fully culpable for the crime, and you spend your sentence in a hospital until your sanity is restored, and then you're transferred back to prison. Now, this is criticized for confusing jurors and offering a shortcut verdict that enables them to avoid difficult issues. Most jurors don't understand that the mental illness of a defendant found GMI does not ensure that they'll receive treatment in prison. Now, this leads to the Insanity Defense Reform Act of 1984, which requires defendants to prove by clear and convincing evidence that at the time of the act, the defendant, as a result of severe mental disease or defect, was unable to appreciate the nature and quality of the wrongfulness of the act. So this is seen as a return to the right from wrong standard. It also basically restricted the scope of expert witness testimony, saying that expert witnesses cannot state any opinion as to whether or not the person had the required mental state at the time of the crime. That is a fact for the jury, or in the case of a bench trial, the judge to determine. Now, civil commitment. There are 39,868 people involuntarily committed in the U.S. on any given day. Now, in colonial America, these people were not the responsibility of the government, but rather their families. And this is the case until Ben Franklin authorizes the establishment of general hospitals to receive and cure the mentally ill as well as the sick and the poor in the mid-18th century. In 1773, the first hospital devoted exclusively to the mentally disabled is constructed, and states begin enacting statutes that will authorize the confinement of mentally disabled individuals. Now, in the 50s, psychotropic drugs become an inexpensive, relatively quick treatment. And in 1963, the Community Mental Health Centers Act is enacted, and this provides funding to establish outpatient treatment centers. And in the 1970s, we see a reform of commitment proceedings. We've talked previously in this chapter about O'Connor v. Donaldson. But also in 1992, the court held an individual who was not mentally ill cannot be involuntarily committed for civil purposes. The standard for commitment is mental illness and dangerousness. Now, there's 3 types of civil commitment. Inpatient, as I just mentioned, requires mental illness and dangerousness. Outpatient helps people adhere to a treatment plan, prevent psychological decompensation, and assist them in successful functioning outside a hospital. But it's criticized as infringing on civil liberties because it abandons that dangerousness criteria. Now, the last type of commitment is sexually violent predator commitment. And the first law addressing this is called the Community Protection Act of 1990, and it's in Washington State. And 17 states have these laws. To be committed, you must have some mental disorder or abnormality that causes or is associated with an elevated risk of future sexual misconduct. And the purpose here is treatment. Now, the law provides a right to a jury trial, but the judge has the ultimate say as to whether or not somebody will be committed. Now, the problem with this is it's scientifically impossible to predict if a sex offender will reoffend. And some argue that these commitments are based on bad science. And that wraps up this chapter.